If you have already been to court and are paying child support at an amount set or approved by a judge, you can apply to the court to change it if you, your ex, or your children have experienced a change in circumstances. You can get information about your court file and access copies of any court orders between yourself and the other spouse by contacting the court services at the court where your matter was originally filed. Some child support orders or agreements that have been in place for at least a year can be modified through the free child support recalculation service. To learn more, go to the web locations shown on your screen. You don't need a lawyer's help to change your child support order. If you don't use a lawyer, you will be a self-represented litigant when you go to court. As a self-represented litigant, you will need to know about navigating the family justice system, using the correct forms, understanding the rules of court, and avoiding common mistakes. This video will focus on those 4 topics, but there is more information on our website if you need more details. The information in this video is for parents who live in New Brunswick. If one of the parents lives in a different province, or if you have a child support order from somewhere else in Canada, the rules may be different. You should call the Family Law Information Line or talk to a family advice lawyer. In New Brunswick, the Court of King's Bench Family Division makes all of the decisions about family matters. In this video, we will call it Family Court. Time to begin.
First, let's look at the laws that apply to changing your child support order. Every court has its own rules of court. These rules say how to prepare court documents, how long a person has to respond, how to serve your documents, and how the court operates. If you don't follow the rules of court, it can affect your legal rights and how long your case takes. So make sure you understand them. If you are a self-represented litigant, you might want to ask a lawyer or call the Family Law Information Line for help. The rules of court are listed on the Government of New Brunswick and Service New Brunswick websites under Acts and Regulations. You can also find a hard copy at the law libraries in Fredericton and Moncton. Focus on these rules. Rule 4, Court Documents. Rule 18, Service. Rule 39, Evidence on Motions and Applications. Rule 72, Divorce Proceedings. Rule 73, Family Division, and Rule 81, Family Law Rule in regions that use a case management process. 2 laws can apply to child support changes: the Divorce Act and the Family Law Act. Make sure you are aware of the child support guidelines. They are part of both acts and apply whether a divorce application has been filed or not. Otherwise, if one parent has applied for a divorce, or if you are legally divorced from the other parent, the Divorce Act applies to you. In all other situations, the Family Law Act applies. For example, you are separated from a common law spouse, or you are still married to the other parent and have separated but have not applied for a divorce.
Now you know what laws apply to you. Let's focus on the process. First, you must find out if your situation has changed enough to request a change to your child support order. Both the Divorce Act and the Family Law Act have rules about what kinds of changes qualify. You can request a change if a paying parent's income has changed substantially, there is an unexpected special expense like childcare, healthcare, or special activities. The child support guidelines have changed. The child is 19 and you want to stop or extend the child support payments. The child does not live where the parenting plan says they will live. For example, if they have moved in with the other parent, or if they now live with both parents equally. If both parents agree with the change to child support, you can file a consent motion with the court asking for a variation. You can find out more information about this by speaking to one of the family advice lawyers at the information on the screen. If the child support order or agreement meets certain criteria, parents may be able to apply for their child support to be changed via New Brunswick's Child Support Recalculation Service, which will recalculate a registered order automatically once per year. For information about this service, contact the service using the information on your screen. The rest of this video will focus on what to do if the parents don't agree. In that case, you need to ask the court to change your child support order. The other parent will be able to respond, and a judge in family court will make the decision.
To start this process, your next step is to find the correct forms. You need to prepare a Notice of Motion, Form 72U, an affidavit. We will explain affidavits shortly, and a financial statement, Form 72J, accompanied by your annual income information verified by your past 3 years of tax returns and assessments, and a current pay stub. Some parts of New Brunswick have a case management process. To find out if your region has a case management process, check with court services in your local court office. If it does, then you should also look at a motion to change, Form 81F, a change information form, Form 81G, your financial statements, Form 72J, your annual income information verified by your past 3 years of tax returns and assessments, and a current pay stub. You will also need to print the following forms for service: a blank response to motion to change, Form 81H, and a blank consent motion to change, Form 81I, if the change involves more than just child support. A consent motion to change child support, Form 81J, if the change involves only child support. Because of the importance of correctly submitting your financial statement, we recommend that you use the PLEIS-NB's Guide to Completing Form 72J, available on our website. We'll talk more about these forms in a minute, but first, there are some things you should know about affidavits.
When someone files a motion to change child support, they need to also provide supporting information. In regions with a case management process, this is done with a Change Information Form, 81G. This is done everywhere else in the province with an affidavit. An affidavit is not a form. It is a written and signed statement of facts that you swear or affirm is truthful. When you swear an affidavit, you make an oath or solemn affirmation, just like you would if testifying in court. If your affidavit refers to other documents, it must state that copies are attached. The attachments must be marked as Exhibit A, B, etc. This detail is important and is a common omission made by self-represented litigants. Swear your affidavit and financial statement by taking them to a commissioner of oaths. They will ask you to swear to the truthfulness of the contents of the documents. Making a false statement on an affidavit is a criminal offense. The role of the Commissioner of Oaths is not to prove the truthfulness of your documents. Instead, they only certify that you have sworn to their truthfulness. All lawyers in the province of New Brunswick are Commissioners of Oaths, and other professionals such as police, court staff, municipal staff, and some SNB staff may also be able to serve in this role. You should check ahead to ensure the person you have in mind can take your oath. You can check their fee for this service when you make your appointment. Be aware that the court requires current financial information. This means you must file the sworn financial statement within 6 months of swearing.
Now that you've identified the forms you need and understand the importance of affidavits and oath-taking, it's time for you to access the forms. Here's where you can find them. The PLEIS-NB Family Law NB website under Quick Links. Changing Child Support Order made in NB. Service New Brunswick, either in person or on their website. You must request the forms by their names. In regions that use a case management process, The court office or the Family Law Information Center at the court will have hard copies of the required forms. Court offices outside of regions that use a case management process may have hard copies of the forms you need. Be sure to check with them in advance. Now that you have the forms, here are some tips for preparing them. Make sure you use the proper forms. Complete the forms thoroughly and neatly. Sign the form and print your name below your signature. If you are asking for the order to change starting back at an earlier date, be sure to put that date in the motion. The forms cannot be e-filed or faxed.
Your documents are now prepared, so it's time to get them ready to file with the court. At this point, you should check with the court you'll be filing with to confirm if there are fees for filing a motion to change. Once you're clear about fees, you can focus on preparing the cover letter and contents of your file. Make sure your cover letter contains your full name and contact information, including your address, phone number, email, etc., the name and address of the court to which it is directed, a list of everything you have enclosed with the letter, and the court file number and the names of the parties. You will file one original and one photocopy of each document. 2 originals will not be accepted. Then, be sure to make an extra copy of all your documents for your records. Once you have your cover letter and document ready, it's time to file them at the family court in your judicial district, either in person or by mail. A complete list of King's Bench locations and addresses is on the New Brunswick Court's website.
Your motion is now filed, and the family court staff will set a date for the hearing. The court will retain your original documents, and the stamped copy or copies are sent to you. Once you receive them from the court, you are ready to serve your documents to the other parent. This is a critical step because a judge will not hear your case unless you can prove the other party knows you are applying for a court order and has been given a chance to respond. Never serve the original documents. Make copies of the court-stamped documents and serve them instead. If you are filing within the regions that use a case management process, you must serve the respondent as soon as possible and include a blank response to motion to change, Form 81H, a blank consent motion to change, Form 81I, and a blank consent motion to change child support, Form 81J. If the respondent is not given sufficient notice of the motion, the hearing may be postponed. The respondent then has 20 days to provide their documents in response. If you are filing outside of regions that use a case management process, you must serve at least 25 days before the hearing. If you fail to do this, the hearing will be postponed. The other parent, called the respondent, then has 20 days to provide their affidavit and financial statements in response. There are 3 ways you can do this. 1. Personal service can be done by you, an adult friend, or a relative, or by hiring a process server or the sheriff's office to serve the other party. 2. You can have someone serve the documents by registered mail. 3. If you cannot find the other party, you may have to use substituted service. Here, the court may order you to serve the documents through email or a relative of the other party. The court may even waive the requirement to serve. If this is your situation, we recommend that you get legal advice. Your server must complete and sign an affidavit of service, Form 18B. This must be sworn in front of a commissioner of oaths. The original of the documents that were served must be attached to the affidavit as exhibits to the affidavit of service. Keep this original affidavit as it will be used in the next step.
Now that you have served the other party and have either received their response or waited the 20 days, your next step is to file the record on motion. If you are filing within regions that use a case management process and the other parent consents to the change, the parties can proceed by filing a consent motion to change, Form 81I, or a consent motion to change child support, Form 81J, asking the court to proceed with the changes. The other party will fill and sign their section of the consent motion to change and send it back to you. You then need to fill your section of the same form and then file it with the court, requesting that the court proceed with the proposed consent motion to change. If you are filing within regions that use a case management process and the other parent does not consent and files and serves the response to motion to change, Form 81H, or 20 days have passed since the respondent was served, or if you do not live in one of these regions, you are required to file a record on motion. If you are filing outside of regions that use a case management process, both parties may also consent to the variation by filing a consent order signed by both parties and accompanied by any necessary income information. This will be reviewed by a judge, and the judge will either make an order, ask for further evidence, or schedule a hearing. The record on motion contains all the documents that have been filed with the court for the proceeding. This includes any documents filed by the respondent. It acts as a book the judge can read before your hearing to view all the important evidence. Any documents you or the respondent have not filed with the court cannot be included in the record on motion. The record on motion must be filed at least 48 hours before your hearing. It will contain an index, a copy of the notice of motion, a copy of all affidavits, including those of the other party, and a copy of all other filed material that is going to be used in the hearing. Be sure to carefully confirm what your record on motion should contain. Here are some preparation tips. Ensure the documents are sorted in the same order as your index. Number each page on the top right-hand corner. Make one copy for you, one for the court, and another copy to give the respondent at the court hearing. Staple or bind each of the 3 records. At least 48 hours before the date of the hearing, file the original record with the same court office where you filed the notice of motion.
Once the hearing is over, the judge may tell you their decision at once. They could also choose to delay their decision, take time to think it over, and provide it in written form later. If that is the case, the court administrator will send you a copy of the court decision. There are a few different decisions you can expect the judge to make. The court order may order the variation to begin either immediately or in the future, make the variation retroactive if it was requested in the notice of motion, or refuse to make the change. To help you achieve the best possible outcome for your efforts, please allow us to identify the most common mistakes made in the process.
Here are the 4 most common errors made by self-represented litigants. 1. Mistakes on the forms. Self-represented litigants often file the wrong forms, fill in the forms incorrectly, miss information, and even forget to sign them. This results in delays in your case. Make sure you have the correct forms, complete them thoroughly, and sign them. 2. Missing deadlines. If you start a family law matter, the other party has a certain period to respond by filing their documents. Sometimes self-represented litigants do not wait until the deadline for a response to pass before moving on to the next stage in their case. Self-represented litigants also commonly miss deadlines, or may not even be aware of them. Failure to either respect or meet deadlines could mean that the judge will either dismiss your case or may make a court order without hearing your side of the story. 3. Failure to serve the other party. Our justice system requires individuals who apply for a court order to give notice of this action to the other party. Failure to serve the other party according to the timelines and rules for service risks delays or dismissal of your case. 4. Failure to swear documents. All family court motions require the filing of affidavits and financial statements that you must swear to before a commissioner of oaths. You cannot add to your story when you are standing in the courtroom at your hearing without the judge's permission. Everything you want the judge to know must be in your affidavit, so neither side is taken by surprise. If you'd like more detailed information about the process outlined in this video, please visit us at the web address shown, or use the contact information to reach us. This video is intended to provide general information only and should not be construed as offering legal advice about your situation.